Right. Morning, everyone. I understand we've still got delegates joining, so I'm just going to give everyone a moment so we hopefully have everyone on board. Then we'll make a start today.
Yeah, we do look like we're in a
I know.
theme park. Ridiculous.
Right.
Can you hear us
Well,
okay?
it's just gone 9:30, so I suggest we
turn up
kick
volume.
off. So for those of you who don't know me, I'm Emma Swan. I'm a partner here in our education team at Forbes. And I'm delighted to be joined today by a number of our colleagues for our education Q&A. So right here with me is Coral Putrell, who is an associate in our education team. Coral's going to be speaking about SEN challenges today. We've also got here on board Ruth and Kat, who are both in our employment team, and they are going to be looking at the new AI guidance that you may have seen has been published very recently by the DFE. We've also got Sam Gorrell, who's here from our property team, and he's going to be looking at some of the considerations that you'll have to take on board if you're looking at leasing or hiring out your school estate to, say, for example, local community groups. I'm also really, really pleased that we have with us Gemma, who's a partner in our education team. You'll see her there waving. And she is here together with Sam King from our litigation team. And they're both here to help answer any questions that may come up during the course of this Q&A. So please do feel free as we go along to jump in. I'm sure you can put in the chat any questions that you have for us along the way. So I thought I would start out today just by covering off some tips that I would suggest you may want to think about when you're managing parental complaints. Now, we decided to talk about this morning because I'm sure, as you're all very familiar, this is something that is coming up as an increasing issue for schools. Managing vexatious complaints. It's certainly something that within our team we're supporting schools with day to day. So a few things to start thinking about. As a starting point, I would always say what we would do if anything comes our way is to have a really good look at your complaints policy. So this is obviously the document that we need to make sure is really robust, because that's going to be the key policy that's going to help you manage a complaint effectively. Now, one of the first suggestions that we would make, and this has sort of come out of our advice that we've given schools over the years, is our recommendation would always be that as a school, you actually have two policies in place. So one specifically for parents, another policy which we essentially say is a policy for members of the public. Now, that could be the neighbor that, has a disagreement with the school over boundaries or anything else. It could, however, be, and this is where it's most likely to be effective, it's the former parent. So basically, if you've got an ongoing complaint from someone who becomes a former parent of the school, what you don't want is a scenario whereby they still have to go through your parental complaints policy, because that is effectively statutory. There are lots of rules and regulations in place as to all the stages that you have to go through as a school, not least, as an academy under, or indeed an independent school, under the Education Independent School regulations. There are quite a number of stages you have to go through. You can skip those. You can basically streamline the process so that for the, should we say, really, really annoying former parent, you can basically say, actually, we've got a far more streamlined process. It makes it far, far easier for you as a school to manage those complaints and just say, actually, we've got a limited number of stages now to go through. We don't have to involve everyone. We don't have to have all the panels set up as you may have done previously. So that will be the starting point of our advice. Also, jumping forward, one of the things that we see for schools that we just flag up is to make sure within the policy, you have very, very clear timelines. So I'm thinking here, this is everything from, at the beginning, having a clear timeline in place. A parental complaint should be made within, say, 3 months. If not, you can deem it out of time. And that's also, as people go through the policy, you want to have clear timelines. So if they don't progress to the next stage, say, within a couple of days of getting a decision, then again, you can deem a further complaint out of time. So that's obviously just in the school's interest, so you don't have matters hanging over. Also, we would always suggest within your complaints policy, you will want to scope out areas that don't fall within a subject matter for bringing a complaint. So I'm thinking here, the obvious things would be omissions, exclusions that have their own statutory procedures in place, just so everyone's clear that, there's a different process to follow there. Then when we're looking at the various stages that you need to go through, for maintained schools, just be aware that actually the default position is you're free within the DfE guidance to choose how many stages you have your complaints policy. However, it's generally recommended, and our suggestion would be that you have 2 stages in place to go through to manage a complaint. And the second stage would obviously be the appeal stage there. For any academies and other independent schools, of course, you have to follow the independent school standards regulations, and there you have 3 stages. So the informal, the formal stage, which may well be your head teacher or CEO, and then also the panel hearing. Now, when we look at the appeal stage, here just a few things that I would just flag up. So for maintained schools, we would expect to see that you have in place a complaints committee, and they may well set up a panel hearing to consider matters. For academies and independent schools, they will need to set up a panel hearing with 3 key members, at least one of whom should be independent. What you will find, though, is that if a complaint is made, however, against the majority of your governing board, then actually the whole panel should in those circumstances be independent. Now, thinking about another point that I will probably make where we see schools sometimes trip over, and that's actually in your response to a complaint. So the problem that we see is that whilst as a school you may well have considered the complaint very thoroughly, gone through an investigation stage, had a panel hearing, what we don't always see is that the decision making is clearly translated into a good, robust response letter. So what we would suggest is, and we can certainly support with presidents here, you need to very, very clearly set out the stages that the complainant, be it the parent or otherwise, has gone through. You should set out clearly any investigation that has taken place, and then also detail the various complaints and the findings and the reasoning for the findings. That's where we often find if a complaint is escalated and say it goes before the DfE and or indeed another regulatory body, this is where schools may become unstuck. So it's really, really important that you set out clearly the reasoning, and so it can be seen, on balance, that it's a considered decision that's being made. Often it will have been, but it's not just clearly set out. You should also include within the letter the next appeal level in the process. So be it going to stage 3 of the process, or perhaps referring a complaint to the DfE. Now, some of the final points that I just would make here are, we are increasingly seeing vexatious complaints coming from parents, and or indeed what are essentially deemed serial and persistent complaints. Now, if it's serial, that is essentially where you've got a parent who's saying, okay, thank you very much. We've been through the process. We're still not happy. And we're going to keep coming back to the school, and we're going to keep asking you really the same or a similar question that we've asked previously, just because we haven't accepted your response. Here, if this keeps happening and a parent is essentially trying to reopen the same matter, this is where actually you can close it down effectively and say, you know what, sorry, this is the end of the matter. We're just not going to respond further. The other part of this is, if you deem a complaint to be vexatious, and here it's really, really important within your complaints policy, you can set this out strongly, all the areas in which you can intervene and say, actually, effectively, enough's enough. We're not going to continue to consider this complaint. The sort of things that may be relevant and what we see are where complaints may be deemed to be, say, obsessive or harassing, and essentially that designed to cause disruption for your school staff. It may be where, and I'm sure you would have seen this as a school, where parents are sending excessive volumes of complaints, and it's never, they never allow you to actually respond to and resolve one. It's you're straight on to the next one. Also, of course, and we can support you very much here, if the language that's being used by parents is abusive or aggressive, or indeed if they're posting comments about the school and members of staff on social media, we would also always suggest that you not just include it in your policy if parents are doing that, but if they're threatening to do that, which is what we often see, then that's when you can effectively close down a complaint as well. Now, in this sort of scenario, we can always support you with putting communication plans in place. So these are the sort of plans that I'm sure you'll be familiar with parents. We can limit communications, so perhaps parents are only allowed to write into one certain member of staff. So it just limits the worry from it being copied into 10 other people. So upsetting so many people's day. Also, we can think about having perhaps things set up so there has to be a third party involved, kind of mediator, who parents should go through in terms of communications. We can also try and limit the volume of complaints. So those are just the sort of areas that we would look at supporting you with. Also, of course, ultimately, you have the fallback option in certain more extreme scenarios where you can ban parents from the school side. Obviously, this is where matters have become more extreme. Some parents we're aware of have turned up outside of school protesting effectively. They're coming onto the site, saying things that they absolutely shouldn't, causing a great deal of upset and worry for school staff, and indeed, obviously other children on the site. In those sort of circumstances, we can support you with, writing a letter to them, setting out the plans to ban them from the school site. There will be an element whereby the parent has kind of a right to respond to that, but ultimately, a decision can be made by the school to effectively ban them from the school site for a certain period that should then be subject to review. That essentially is what I wanted to cover off today, which I hope has given you a kind of whistle-stop tour of school complaints and has hopefully given you a few things to think about. If anyone has any questions, please do just, flag those up to us, and I'm very happy to come back either now or later on. If not, I can't see anything just at the moment. So what I will do is pass you on now to my colleague, Coral, who is going to talk about SEN challenges. So over to you, Coral.
Thank you. Morning, everyone. It's really lovely to be here. So as Emma mentioned, are increasingly being asked about how to successfully challenge the local authority when they're looking to name your school in a child's plan. A recent DfE report highlighted the percentage of pupils with a plan has increased to 5.3% from 4.8% in 2024. It sounds like quite a small jump, but when you put it on top of all the other stresses and strains that schools are facing, it's a real challenge. So being well equipped to challenge the local authority in these cases will put you in good stead. So a child's parent has the right to request a particular school through a maintained school academy, Section 41 approved independent school, to be named in the plan. And when they do so, the local authority must comply with that request, except in really specific circumstances. So we'll talk about those specific circumstances. Where your school's been requested, they must consult with you and send you a copy of the draft plan before you're named, and you are required to respond within 15 days. So that's 15 calendar days rather than school days. So it's a bit of a shorter time frame, particularly when you take account of weekends and the rest of the work you have to do within your role. So what we recommend is you have a template document that you can turn to rather than reinventing the wheel each time you need to respond to a consultation. Have that template document you can use as a starting point, and that's something that we put in place for schools quite frequently and they find quite helpful. So the specific circumstances in which the local authority will not comply with the parent's specific request to name your school in the plan are the grounds that you need to rely upon to successfully challenge. So those are that the school is unsuitable for the age, ability, aptitude, or SEN of the child. The attendance of the child will be incompatible with the provision of efficient education for others, or it will be incompatible with the efficient use of resources. So as I say, it's vital that your challenge is based on one or hopefully more of these grounds to be successful. So starting with the first ground, unsuitability for the age, ability, aptitude, or SEN of the child, you need to be highlighting any detriment to the child's ability or needs that may occur if they attend your school. And when you're doing so, refer specifically to their needs as outlined in the draft plan. Keep in mind that the local authority will consider steps that could be taken to remove or reduce that incompatibility. So think ahead, get ahead of the local authority. Consider any reasonable adjustments that you could put in place and why they still would not be all that helpful. So when we're thinking about challenging on this ground, we're looking at things like suspensions or exclusions a child may have been subject to previously, or more general behaviour incidents. Use this together with information about your school to prepare a risk assessment, and then use your Ofsted report and school prospectus, for example, to put together a suite of evidence. You could also consider the child's current attainment and how it's lagging behind their peers, the child's expected level of progress if they were to attend your school, and the provision that would be needed to help them to close any gap, and comment on generally how well the pupil, based on their needs, will be able to thrive in your school. And when we're looking at that, it's a bit more holistic, so to say. So, for example, if you have a child who becomes emotionally dysregulated in loud and noisy environments and it causes a flight response, if your school is a busy secondary school with noisy teenagers and you're backing onto a main A road, it's not going to be suitable for a child who's likely to become dysregulated in that environment and want to leave the school premises at the drop of a hat. So it's unlikely that your school is going to be an environment in which that child can thrive. So the second ground, incompatibility with the provision of efficient education for other pupils. As a starting point, efficient education means providing for each child a suitable and appropriate education in terms of their ability, aptitude, and any SEN that they may have. And when the local authority is considering whether a school is suitable on this basis, this means the children with whom the child with the plan will directly come into contact with on a regular day-to-day basis. So in practical terms, that means their classmates rather than the wider school body. And there needs to be a strong finding of incompatibility rather than just evidence of some impact on other children. And it's quite a strong test of incompatibility. So it's a high threshold and needs clear evidence of the difference that the admission of the child with the plan would make, which students would be affected and how they would be affected. So we're looking at referring specifically to the pupil's needs and education provisions set out in the plan again. And you might, for example, comment on the health, safety and well-being risks that the pupil might pose to other pupils as a result of their needs. Any additional provision or adjustments that might be necessary, such as changes to classroom layouts, how the placement would affect the learning of other pupils in the classroom. You can also look at whether your school is already at capacity, but keep in mind, don't rely solely on that ground. The courts have said that a school can be named in a plan even if it's full, and the local authority needs to be relying on the quality of the education provided to other pupils falling below the threshold standard of efficient education in order to not name the parent's preference in the plan. So the final ground, incompatibility with efficient use of resources. When we're talking about resources, we're talking about budget and other physical resources, including staff, and again, refer specifically to the provisions set out in the child's draft plan. So preference can only be displaced on the grounds of being incompatible with the efficient use of resources where the extra cost is significant or disproportionate. A court case said that a difference of £2,000 to £4,000 was not going to be significant enough to make it incompatible. So when we're looking at this, for example, look at the extra staff and skills that might be required to meet the child's needs in the classroom, and also their needs during break time and lunchtime. Look at the type and level of training required to upskill staff to meet their needs, and detail the cost of any specialist resources or equipment that might be needed. And again, make sure it's really clear evidence with lots of figures to make it as strong as possible. So hopefully if you follow those sort of recommendations, basing a challenge on those key grounds, you'll be successful and your school won't be named in the child's plan. If that's the case, parents do have options. They could appeal to a tribunal against the decision not to name the school in the plan. That's an appeal against the local authority rather than the school, but you would be expected to support it in the proceedings, so providing witness statements, for example. Again, that's something that we can support with, and we recommend you have a template available referencing your Ofsted report, your school's context, just to save you time and make it a bit more of an efficient process. Parents can make an application for judicial review. In reality, we don't really see this because of the time and cost expenditure. We're talking tens of thousands of pounds, so we don't often see it at all. And they can also complain to the Secretary of State, and the Secretary of State can make directions, but they wouldn't intervene where there's another avenue of redress available, such as a tribunal. If, however, the local authority goes ahead and names your school in the child's plan despite your comments, you don't have the option of appealing to a tribunal, but you can commence judicial review. And the court will intervene if the decision was unreasonable or disproportionate. You've got 3 months from the date of the decision to apply, so pop it in your diary just in case it's a course you want to take. You can also make a complaint to the Secretary of State. We support schools quite frequently with making a complaint. And again, the Secretary of State can make a direction. What we've seen recently is success in schools challenging on the basis that the local authority has not conscientiously considered the response to the consultation. So pursuant to the SEN code, the local authority does need to conscientiously consider your response to the consultation. If, for example, they return within a few hours and say, thank you very much for your thoughts, we're going to go ahead and name your school in the plan, it's arguable that they haven't actually given it much thought or consideration. An indication that they have done so would be coming back, even if it's a rebuttal, but coming back and saying, we know you think this, have you considered putting this adjustment in place to overcome that hurdle? That sort of dialogue would indicate that there has been conscientious consideration. If you consider that they haven't done so, make a challenge, because you may be successful on that grounds. We've seen success. What we hope you would do is not only keep a note of the dates that communications have been sent and received, but specific times, because if you return your consultation at 4 p.m. on a Thursday and the local authority respond at 9 o'clock the next day, it might look like there's been a day between, but actually it's only an hour or so. So keep a note of specific times of communications as well. I'm finally just going to touch on reasonable adjustments and auxiliary aids, because if a child is placed in your school, you'll no doubt have to consider reasonable adjustments pursuant to the Equality Act. The duty to make reasonable adjustments is anticipatory, so it means that you need to be ahead of the curve and thinking, what might this child need to be able to allow them to overcome any disadvantage? Don't wait for the parents to say, we would like this put in place. When you're considering what's reasonable, it's going to depend on the circumstances of the individual case. And it'll be considering things like whether it would actually remove the disadvantage for the child, whether it's practical for you to do it, what steps you've already taken and how effective they were, any implications on other resources, and any level of disruption that it might cause. You should also consider the cost of the adjustment when deciding whether it's reasonable. For example, some adjustments could be more difficult for a smaller rural primary school to put in place than a larger school which potentially has more resources at its disposal. So it's very much a case-by-case basis, considering what would actually be sensible for your school to do. And since September 2012, so a little while now, schools have had additional obligations to put in place auxiliary aids for disabled pupils. So that could be hearing loops, adaptive keyboards, or special software on devices. That may be that auxiliary aids are specified in a child's plan, or they might not, but again, you need to be considering it either way. And again, it's a case-by-case basis. What's considered reasonable for one school might not be for the other. And also consider that it's likely to be unreasonable for a school to provide an aid, so for example, a hearing aid, where it's needed for all aspects of a child's life rather than just for their education or for their participation in school life. So take that into account as well. And finally, just to end on one last note, parents of disabled children do have the right to make a disability discrimination claim if they believe that the child has been discriminated against by the school. And they can make a claim against any school about alleged discrimination, and that can include in the matters of making reasonable adjustments and providing auxiliary aids. And what's important to note is that you might have got 99% of it right. If there's 1% where you're not quite there, there is scope to potentially bring a claim. So if you're ever in doubt, seek advice, because it could help you get that 1% over the line as well. As I say, we're well experienced in supporting schools with these matters, helping you put in place template documents to save time and save your valuable resources. So get in touch if you need anything.
Thank you, Coral. That was really helpful. It's probably worth just flagging up as well. I know there have been a number of JR, so judicial review cases in the last year or so. And I think what has been really interesting, really important to know is that these were brought by academy trusts actually against their local authority, because they just found that they were being effectively overwhelmed by the number of placements they were being asked to take for children who they, absolutely wanted to help, but they just weren't suitable placements at all for these children who had plans in place. And what has been really interesting is that in both of these recent cases, the schools were actually successful in their appeals. So it is certainly something that we are finding increasingly if you are really concerned as a school that you couldn't, safely take on board a particular student, for the impact on other children, on staff, it's an unsuitable placement. It is actually worth going back and trying to challenge that. And as Coral mentioned, she frequently sort of provides training and workshops for schools just in supporting you and giving advice, whether it's in your responses, initial consultation responses to local authorities, or kind of further down the line if you're considering appealing to the Secretary of State. So yeah, that's just worth bearing in mind. But thank you very much. That was great to cover that off. Now I am going to move on to Sam Gorell, who I understand is going to be talking about the school side, where you may want, for example, local community groups to come on and rent part of the premises in the evenings or early mornings. So this is something that he's going to be talking through, how you should best go about formalizing those arrangements so everyone knows what's right, what's wrong, what they can do, and obviously you have to very much think about safeguarding requirements and getting everything in place so you all have a clear idea as to what everyone should be doing. So I'll just pass over to Sam right now.
Thanks, Emma. Hello, everybody. It's good to be back with you all. We've had a question that's come in advance, which basically asks the sort of points that Emma's just touched upon there. A school that's been approached by a local community group who want to use part of the school building outside of school hours. And the question they're asking is whether they put a lease in place or whether they can proceed with just using a license. And it's a sort of question that we do get asked from time to time. I think it highlights the difficulty that all landowners and occupiers of commercial premises can face when deciding how to document the occupation of a property on a short-term or ad hoc basis. In order to be able to answer the question, it's important to understand the key differences and elements of a license and a lease. So if we look at a lease first, what is a lease? Well, a lease is an estate in land, which is just to say it's a form of land ownership. It's a document that grants a right to exclusive possession of that land for a fixed or determinable period of time. So a person will be seen to have exclusive possession if he or she can exercise the rights of a landowner and exclude both the landlord and any third parties from the land. There may be an exception to the extent that the landlord has reserved rights of entry, for example, to carry out works. But for all intents and purposes, if you have a lease, then you are the owner of that land or that particular space in that building. So thinking about the question, if it's the case the local community group are to have exclusive use of that part of the premises that they're wanting to use, then it's likely that the school would be wanting to grant them a lease. I think a clear example of this is when you allowing a nursery perhaps to occupy part of the school premises. We often see schools with add-on nurseries on the basis that the nursery would be the only party that uses that particular space, then they'll be seen to have exclusive possession, and therefore a lease would be the most appropriate form of occupation agreement. And we've also seen similar lease arrangements granted for local scout groups in respect of outbuildings that are often used as scout huts. I think if you're thinking about granting a lease, it's important to check the terms of the document, which grants you, the school, an interest in your school land and buildings, as these can often place restrictions on the types and lengths of leases that are capable of being granted. And you may be expected to apply for consent of your landlord or the transferor. You'll also be expected to obtain DFE consent, and if you're granting a lease, you'll need to go about completing the necessary consent forms in order to obtain that. One of the key benefits of a lease is that you can pass ownership and control of that part of the land or that part of the building to your tenant, your leaseholder. They'll usually be responsible for keeping any standalone buildings in repair, or any internal parts of any part of the main school building in repair. And they'll also be expected to comply with all legal obligations in respect of that space. So if that's what the kind of intention is, then again, it's likely that you're looking at granting a lease rather than a license. But at the same time, that can also be the biggest disadvantage, because you may need to continue using that space yourself, or you may need to make it available to third parties as well. So in that case, it may be more appropriate to grant a license. So what is a license? Well, a license is simply permission for a licensee to do something on the licensor's property. So it's that permission that the licensee has that prevents their use of that space from being a trespass. It's often, in that sense, it's seen as a kind of more formal arrangement. But many licenses will be documented in writing regarding the use of property. And if the key elements of a contract are all present, then a contract will be formed, which will mean that you're able to enforce the terms upon which the licensee occupies. So if they weren't paying any license fees, or they weren't doing what was expected of them, then you could look to enforce that and claim against them to make them carry out their obligations. But ultimately, if it's in writing or if it's seen as a contract, it doesn't take away from the fact that it is a license. It will remain a personal right only, permission that they can use, and only they can use the space. And you won't get the same level of security, the ability to remain there, as you would do with a lease. And the provisions regarding length of occupation will be clearly set out in the license document itself. In the same way that a lease can be identified through the key element of exclusive possession, one way of spotting that a license exists is to look for the absence of exclusive possession. So a license should only be used where somebody isn't intended to have exclusive possession of that particular part of the premises. So again, in our question, if the school or other third parties will be using the same space that the local community group wish to use, either at the same time or other times of the day, then it's likely that a license will be an appropriate form of occupation agreement. Perhaps a clear example of that would be if you were hiring your sports hall to like a local sports group, then given the fact that others will be using that sports hall, either the school or other third parties, and the fact that the school will probably, the sports club will probably be using it on a fairly ad hoc basis, then that arrangement would be better served by a license agreement rather than a fully negotiated lease. It may be in that particular instance that you'd look to have a booking system in place. So rather than having to sign up to an individual agreement, you'll be able to hire the hall or any other parts of the school on a booking system via your usual terms and conditions. But even if it's a kind of flexible arrangement like a booking system, then the legal basis upon which it's being occupied and used would still be a license. Also, a key feature of a license would be where you want to reserve the right to move them to other parts of the building. So because you're not granting exclusive possession, your agreement can contain what's often known as a lift and shift provision to say that you'll move them to other suitable parts of the building if there's a need to do so. So here in our question, if the local community group needed to use a classroom and that was all they required, then the license agreement could provide for the school from time to time to decide what classroom is to be used. So it's not a fixed kind of place within that school building. And that lack of exclusive possession, again, will mean that it's more likely to be a license. Licenses tend to be used for shorter periods, usually no more than 6 months. So they are suitable for seasonal use. And they're usually less strict on repair, insurance and other obligations. you will retain ownership and control. You'll be responsible for repair and maintenance. The community group or the sports club will just be coming in to use it. They won't be responsible for that space in any way, shape or form. That's usually the case. Again, it's important to check the terms of the documents upon which the school or trust has the interest in its land and buildings. Often it can place limits on sharing occupation, which would include granting a licence. But the standard DFE 125-year lease does allow for sharing of occupation with any group that has a similar use to the school, so mainly education and community use, without having to obtain the consent of the landlord. And you wouldn't necessarily be expected to obtain DFE consent to grant a licence. A final point to end on is just an important note that just because an agreement is labelled a licence doesn't necessarily make it so. So if you're thinking that you might want to avoid some of the complications of granting a lease by just pretending to grant a licence, that might not necessarily be what happens. Parties can opt in what is in reality a lease into a licence just by calling it a licence. A licence will be interpreted as being a lease if the nature of the occupation is such that it appears to resemble a lease. So once again, if it grants, or if you're granting exclusive possession and it's for a fixed period of time, if a licence was put in place for a particular organisation and for only that organisation to use part of the school for the duration of each academic year, and it continued to be renewed every year on a similar basis, then I think it's likely that an implied lease will be deemed to exist. So that continued use of that same part of the building by the community group or that third party will mean that even though you might be thinking of it as a license, it will in fact be a lease. What's particularly crucial to note here is that if that part of the building is being used for business purposes, which is given quite broad definition under the relevant legislation, then they could be seen to have security of tenure, so certain legal protections that allow for them to remain in place, in possession, under the Landlord and Tenant Act 1954. If there is a lease and it is a business tenancy under that legislation, then, as I said, they'll have the right to remain even after the term of the lease has expired. And they'll also have the right, the ability to request a new lease at the end of that period as well. And only the landlord can only look to recover possession on certain grounds as well, which can make it more difficult to end that relationship. So if you have any doubts in your mind as to whether somebody is occupying under a lease or a license due to the fact that they've got exclusive possession, then it may be most prudent to call it a lease and put in place the necessary provisions that mean that you contract out of those statutory protections and that you can deal with it on an individual basis for a fixed period of time and then look to renegotiate at the end of that. You can always put in place break clauses which give you flexibility to end a lease early and also give yourself the ability, as I said at the end, to either walk away or put in place a new lease on different terms. So it's best in that sense to try to recognise it for what it is rather than pretend it's something else and find yourself getting your fingers burnt. So hopefully that helps. Ultimately, I think the answer is, in terms of what form of occupation agreement is best to use, be it a license or a lease, it's going to always depend on the context of the arrangement and what the proposed use is. There's not a one-size-fits-all answer, but as I said, the key thing is likely to be exclusive possession and whether somebody is occupying it on their own. We're always happy to give considered advice on that point. So if you did have any questions or if you did want any occupancy agreements check in over, or you've got plans to put in place a letting going forward, then by all means get in touch and we'll be happy to help.
Thanks, Sam. That was a great overview. I think it's certainly probably worth mentioning. We've definitely seen an increase, I'd say, probably in the last year or so, of schools who have been asking about, say, putting in place higher facilities agreements. I think obviously in the current financial climate, it's not least because of the importance of trying to raise funds for your schools, trying to find other ways of actually bringing in some additional finances. So, if that is something that you're thinking about, we would certainly suggest, what we've seen sometimes is a kind of a one-pager high facilities agreement that won't be sufficiently robust. I can see Sam nodding there to adequately protect your school's position. It was, I think it was last year, the DfE brought in some new guidance, and that actually set out some quite stringent safeguarding obligations that must now be included in any hiring arrangements. So you make sure you're basically pushing back the safeguarding obligations onto the third parties who are using the school side. So there are a lot of elements to consider here. So if it's something that you're reviewing, then just do please bear that in mind as well. Right, we are going to move on now.
Emma, sorry,
oh,
I put my hand up. Sorry to interrupt. I
Sorry,
just want
Gemma.
to add something to that. I've had a couple of large trusts in the last 12 months who have also had it flagged to them by the DfE for tax purposes, that potentially if they're earning over a certain amount from these sort of sessional licenses or these agreements of muggers or sports halls to like local football clubs or anything like that, if it's over a certain level, they've actually advised that they consider setting up a separate community interest company. So that's just another element of it, that potentially you could have a tax saving by doing that. And I think I've set up so far 2 or 3 of those companies as a result of tax advice that the clients got. So I just wanted to flag that. Sorry, I didn't mean to interrupt.
Not at all, Gemma. That's a really good point. And of course, by you doing that, it also ring fences risk away from the core school. So yep, that's absolutely a really good idea when you're getting to that level. And certainly, I know historically it was around 80,000, I think, but I wouldn't like to say if that's
Yeah, no,
that
that's right. So basically with the big trusts that have sort of 10, 11 schools, obviously if they have lots of facilities that they're letting out all of the time, you can soon hit that level of 80,000. So yeah, sorry to interrupt.
No, not at all. No, that's really helpful. Right, I will move on now. To finish off, we're going to ask both Ruth and Kat, I believe, are going to be talking to us about the latest DfE guidance on AI in schools, which of course is all over the news now. So I'm sure it's something that you're thinking about within your school, be it the use of AI by staff and of course increasingly by pupils, and how you can best make that work for your school. So without further ado, I will hand over to both of you to talk about the latest guidance.
Thank you. Thanks, Emma. Yeah, hi from our Manchester office. Gemma and I in the Manchester office. We're not
in a different location. This is very exciting.
And we're not in a theme park. It just looks like a theme park. We're definitely not. We are working. We're in the Manchester
Emma
office.
thought we were on a roller coaster, didn't you, Emma?
We're definitely not.
I wish.
I know. So we just thought it'd be quite topical to talk about AI because, like Emma said, it's in the news. AI in education is a really difficult subject to navigate. And the government produced a policy paper on it on the 10th of June. Spoiler alert, it doesn't give you all the answers, unfortunately, but it does give you things to think about, as education establishments. And within that, there is a really helpful PowerPoint presentation. You kind of got to click through the policy paper. It's not obvious that it's there. But there's this PowerPoint presentation that has these 10 audit pages, which I think are quite useful, really. And what they do is they kind of give you different scenarios, and then kind of say, look, answer these questions. And then you can assess kind of where you are as an organization, as to kind of, you know, where you are on your journey, things to think about, safeguarding measures to put in place. So I think it is quite useful to look at that. And obviously it's not helpful for me to go through it all, because it depends where you are on your journey, but it is useful just to look at the policy paper, then have a look at that PowerPoint presentation. But within the policy paper, it obviously talks about generative AI, and that seems to be the main issue here, because obviously generative AI is a model whereby it's trained on large volumes of data from diverse sources. And that's the issue, isn't it? In that if you're using something like ChatGPT, you're not quite sure where the information's coming from that you're getting back from it. And also, Gemma, with a data protection hat on, you need to be very careful about what you're putting in, because you don't want to be putting in any kind of, you know, sensitive personal data, anything where people can be identified from, because once it goes into those generative AI models, you're not going to get it back. So, you know, you've really got to think about safeguarding. And I think the flavour that you get from this policy paper from the government is that, you know, yes, AI is great for efficiencies, and you know, the DfE are all for, you know, taking burdens off teachers and you know, really enhancing the learning of pupils, but all the way through they're caveating everything to say, but you've got to use it safely. And that's kind of the balancing act, which for you guys, it's just something else to think about. But you know, within the policy paper, it does say, look, AI in education can be really, really useful, and gives examples, especially I suppose from a teacher point of view, as to kind of where you can reduce workload slightly by producing activity focused slides, you know, producing things in a way that perhaps you hadn't thought about before. Video presentations with accompanying transcripts, and AI can produce those for you. Summarizing lots of information, that's a really useful tool. You know, the
Lesson planning as well.
lesson planning, yeah, exactly. You know, activities to consolidate knowledge, you might have other suggestions about that, and templates as well. So, you know, within the policy paper, it says, look, you know, you can use it for these things. I mean, we were talking to an organization who perhaps use it for marking as well, which I think, you know, there's pros and cons for that, because you wonder, if you're using it for marking, how is that teacher actually going to know how that pupil's doing if you're just kind of feeding it into an AI model? But equally, if it's something that is quite laborious, as long as you're kind of doing sense checks and you are perhaps using it for a certain amount of time, that might be something. But it's whether you've got the appetite for that, and how that's going to work. But I think within the policy paper, I think that the DfE seem to be more in favour of generative AI when we're looking at it from a teacher point of view, because obviously teachers, they're not going to be exposed when they're using ChatGPT. Hopefully they will know kind of the pros and cons of it, what they can and can't do, and perhaps can use it to help them with their role. The caveats are always about the safety of pupils. And, you know, you've got keeping children safe in education, you've got safeguarding concern, you've got data protection. What you don't want to do is kind of let pupils kind of free, unsupervised on ChatGPT, because you're not quite sure what they're putting in and what you're going to get back. But, you know, I was at a talk recently about AI, and it was a really positive talk, and it was talking about using generative AI for pupils, obviously supervised within an education setting. But it was saying, you know, for those pupils who perhaps sometimes struggle and they've just got a blank page in front of them and they're just thinking, I don't know where to start, and people can feel panicked and stressed, and then sometimes they just you know, throw the towel in and just think, I just don't know. Generative AI might give them a starting point at least, you know, and something to kind of think about, to kind of get them on the way, and kind of help them to kind of get over that blank page scenario. So that's one way to look at it. And also, you know, with generative AI, you've got to put prompts in, haven't you? You've got to kind of ask the questions. So in some respects, that can be quite useful to consolidate learning, to kind of say, you know, this is the topic, you know, can we take it further? What can you ask? So it shows that you've understood the topic to ask the further questions, you know, what prompts would you use? So in some respects, that's quite a positive thing. It's making people think outside the box, and rather than just kind of learning a textbook from rote, you know, you're kind of saying to students, probably, you know, older students, those in sixth forms, potentially higher education, kind of thinking, well, what prompts can you put in? So, you know, there are positives to it. But it's about kind of monitoring, I suppose, how it's used.
AI is a thing. It's coming. It's happening.
Yeah, it's not
You
going
know, and
away.
we can't just sit there and not acknowledge the fact that it's on its way.
Yeah,
So I'm very much of your train of thinking, Kat, which is this is a thing. It can be used, you know, for good things, but just be careful.
yeah.
You know, use your common sense. Think about what you're putting into it. But AI is coming, and we've got to embrace it, because otherwise you're just going to end up getting left behind.
Yes, exactly. And I
Kat,
think
jump in there as well, just to say, I was at an event last week, and it was again a talk on a bit of a talk on AI. It was a very neutral talk, positives, negatives, all balanced out. One of the things I thought was really, really interesting was that the tech that this guy was showed that you could do like the school trip letters, you know, with the return slips on the bottom, and they could basically just put some markers into AI. It would generate the letter with the return slip. Now, the caution was, of course, please do read the letter. Don't let it just generate and then send it out. Obviously, check it, tweak it, change it to your style and how you want it. But Gemma will be very proud of me, because I intervened in that meeting to say also they were talking about ChatGPT and also Copilot, and there are other brands available, but that's what the ones they were talking about. And they were saying if you're not signed in with a subscription to your school, that any information you put in there can be taken and used to create other AI in the future, and can be effectively spat back out at you. So I piped up immediately and said, please also be aware through GDPR and data protection that obviously you've got to be careful about the information that you're putting in, and also what devices people are using at home, and what information are they putting in, and what's coming out. So but again, it was a fairly neutral talk about the pros and cons, but that it did show that there's a lot of workload advantage and reductions that can be made to things that
Yeah.
would normally take ages to do.
Yeah, I think the ideal is kind of having this, you know, custom model where you know, your school kind of builds their own AI model, because then you're completely in control of it. And you know, and I've seen one where it was for a secondary school, but they used it whereby students logged into it, and you know, their timetable was there, their lunch choices were there. You know, it was very much, you know, they could say like, you know, when's my next maths lesson, and it would just pull all that. So that was quite a useful tool, really, just to kind of make it easier for students to navigate their way around the school day. But yeah, I think the custom models are expensive, aren't they? So you know, if you are using ChatGPT, generative AI, it's important to think carefully about that. And the policy paper does say, look, you know, teachers, you can use this to consolidate, you know, lessons that you're delivering or producing slides, etc. But it says that, look, the outcome may not necessarily follow the curriculum. You know, because someone could have put something in that was incorrect or out of date. So you know, you always need to check that. And I think what in the policy paper it does talk about, you know, AI and assessments, and I think the acknowledgement is that you know, what assessments need to catch up with AI, because you know, it's on teachers to kind of spot plagiarism. But you know, a teacher who may be new to a subject may not know kind of, you know, where that's come from. And of course there are plagiarism tools where you can spot that, but again, extra cost. So that's certainly something that the policy paper says, look, we're going to have to keep. Just a final point just about the policy paper, it kind of just gives indications of what schools should be thinking about, which is quite a useful takeaway, I suppose, in that, you know, if you are going to use AI, you need to state the intended use of the AI, think about the benefits and make sure they outweigh the risks. So using those audit papers in that PowerPoint presentation, I think that's really useful for a starting point. think about risk assessments, you know, risk assess, have you thought of safeguarding pupils, safeguarding teachers? Have you thought about who's using it when? As Ruth said, that's really important to carry out those risk assessments. Think about your statutory obligations. That's really, really important. That should be always at the forefront of everything we do with AI and education. You know, keeping children safe in education is absolutely key. Make sure you've got appropriate safeguards in place. So, you know, limiting who can access AI, supervised or not. That's really important. Age restrictions, you know, certainly don't think about giving pupils kind of a free rein on ChatGPT, because you're not quite sure what's going to come back. But like Gemma said, it's here to stay, so they need to know how to use it. It's really hard to balance that. There is government guidance on product safety expectations in AI. There is lots of government guidance out there as well that's probably worth having a look at. And also, this is kind of where we come in as well, I suppose. It's like reviewing your policies. So, you know, especially for higher education, secondary education, thinking about homework policies, things like that, unsupervised study, devices, bring your own devices, etc. So it's important to think about your policies and making sure they're up to date with developments in AI. But yeah, the government have asked and they're funding Ofsted to conduct a study on the use of AI. Things are moving forward. But yeah, I just thought it'd be useful just to kind of highlight this policy paper. I'm sure we could share the link to it after this session. But it's worth having a look at it. And if you're not using AI, think about how you can use it. And if you are using it, just thinking about these safeguarding issues, thinking about safety in AI, but also how it can be a positive as well.
Thanks, Kat. That's really useful. I know it's there's a lot to take in, but I think I can't see that there's any questions that have come through. We're obviously on time now, so really just to say thank you to all the delegates for your support all year long. We're nearly at the end of the academic year. We know that you're probably crawling towards the end of term now, and looking forward to hopefully some rest over the summer. We will be back in the autumn term. Updates to follow with dates. We haven't planned our summer after the summer yet, but we will do that while you're taking a break over the summer. And we'll be back in touch for more Q&A sessions and more exciting things to come next year. So enjoy a well-deserved rest, and we look forward to seeing you back in the new academic year. Take care.
Thanks, everyone.
Bye.
Bye.